So what happens when you have a loved one that passes away and they own real estate and you now need to sell the real estate and you learn that they had no will? If they had a will, no one seems to know where it is, who handled it. You don't have a track of attorneys to talk to, so you have to assume that there is no will. That is a situation that can be really complicated, especially when you're ready to sell real estate. I'm Karen Hayes, and I have been in the real estate industry for over 4 decades in the state of Texas. In other states, I know there are different rules and regulations that apply to this very same scenario, but typically there's going to be some similarities that you're going to be able to relate to, and then you can go to your attorney in your area and ask specific questions because it can get really complicated. I have dealt with hundreds of these transactions. Many families are caught off guard when you learn what has to happen, and then you have certain situations that maybe aren't the easiest to resolve. So let's start with, you're ready to sell. Real property is real estate, whether it's lots, acreage, property with a house on it, commercial property with a building, or anything sitting on dirt. So that would be real estate, real property. And when someone dies without a will, or you have no will, someone believes there's a will, but no one can find the will, then you basically have no will. You have to determine who the heirs at law are. And at that point, it becomes much like subscribing to Ancestry and working a family tree. And I will tell you now with Ancestry.com, that has saved me numerous times since that app has been around, because there are just times where you can only do so much background checking and trying to locate people on the internet. Before the internet, it was really hard. So we live in a time now where it's not quite as hard, but honestly, if you have a large family, it can get really complicated. So let's talk about when you're in a family situation and you've got a person who passed away and they had ownership in property, real estate property. Let's say they are the only person in title. Even if they were married before, maybe they divorced, maybe their spouse passed away already, but that person was not in title with them. They solely owned this property before they were married or had anyone else in ownership with them. Different states handle that differently as far as marriage goes. So that's the first question you'd want to ask, because even though someone owned the property, if there is a home on the property that another person lived in as their homestead in Texas, that other person has a homestead interest in the property, even if they didn't buy it with that person. So it can get really complicated. But let's assume that it's one person, they're not married, they weren't married, they own the property solely in their name. They passed away, there is no will. When a title company does the abstract search to determine who is in title, that's the first step. So title work comes in, and everyone's expecting that, yes, it's the one person who owned the property. At that point, because there's no will that anyone can provide, you have to determine who the heirs are in that person's life. So you start with, were they married? And if they were married, how many times were they married and who were they married to? You have to ask questions to actually build up a story of their life that becomes an actual affidavit. And that affidavit is called, in most states, an heirship affidavit or an affidavit of heirship, same thing. It's to determine who the heirs at law are for this person. So as you begin answering those questions, usually it's a family member that is working on this, and if there is no family member helping in the transaction and a real estate agent is working with a friend of the family, then it gets a little more complicated, but they still have to answer the questions. So the first thing that you're looking for is a copy of a death certificate. So that is proof that that person is deceased. The death certificate contains information, and that's helpful, particularly if that's all you have to go on at the time. So obviously on most death certificates, at least in Texas, you do see who the parents were of the deceased person, and if they were married at the time of their death, who that person is. And that also helps us find out the date of their birth and the date of their death, which are facts that we need to know in order to get the documents prepared. At that point, if that person was married one time or many times, we have to document each separate marriage. In doing that, we have to know when that person married the first time, if it's more than one time, the second time, or the third time, who they were married to, when they were married, and when that marriage terminated. Did it terminate through divorce or did it terminate through death? So those are important questions that have to go on the affidavit. Obviously, you can see that it makes a lot of sense why someone would need to have that information, because each time they were married, there could be children from that marriage, which brings us to the next question. So when they were married to this person, were their children born or adopted into that marriage? That's the first question. If there were, how many children? Who are those children? What are their names? What is their date of birth? Where do they live now? You would need a list of children born within a marriage. If there was more than one marriage, you go through the same story. When were they married? When did that marriage terminate? How did it terminate? Through divorce or death. How many children were born of that marriage? Same thing. What are their dates of birth? What are their names? Where do they live? Now, just with those facts alone, you can see that sometimes people don't know. They just don't know. It's been 50 years or 40 years, even 20 years, and people aren't sure if they weren't an immediate part of that family. So in order to prepare the affidavit in the state of Texas, we have to have it executed. Once we get all the facts and we can prepare that affidavit, then it needs to be signed by 3 parties. One who is an heir, meaning a spouse or a child or a stepchild or an adopted child or a brother, a sister, or another immediate family member, whoever is considered an heir to them. Then 2 people that are not family members also need to execute it in the state of Texas. And that may be the same for other states. Some states may only require 1. But it's really important that you know this, because when you need 2 other people to execute an affidavit and they can't technically be married to each other, because in Texas it's recognized as one person when it's a couple. So you would need 2, we call them disinterested parties, because they are not relatives. I've often heard, well, we don't have any people that are still alive that knew my mom or my dad or my aunt. They're all deceased. So what we're looking for is a neighbor, a church member, a pastor, a doctor that they had been going to for at least 10 years, preferably someone that knew them when they were alive and knew them for at least 10 years and knew their family history, so to speak, because you need to know the facts about the family in order to answer those questions that are needed. That's just a start. I am Karen Hayes, and this is part 3 of my estate series. As you can see, we just got started with an heirship affidavit. I'm not an attorney. I have been in real estate for all of my adult life. I am a real estate agent now, and I have been an escrow officer in the title business for over 4 decades. My life situations I've handled in my work, so you can get prepared for these questions when the time comes and you're not left trying to sell a property and you have no idea where to start. Join me on the next one as we build the heirship affidavit. Thank you.